I planted tomatoes in my own yard, so the HOA sued me and lost their whole board. How could planting tomatoes in your own yard lead to a lawsuit? And what could possibly cause an entire HOA board to lose after making that decision? Hello everyone, and welcome back to the channel. If you enjoy compelling HOA justice stories inspired by property rights, community conflicts, and unforgettable legal battles, make sure to subscribe and turn on the notification bell so you never miss a new story. Thank you for spending your time with us and for supporting the channel with every view, comment, and subscription. Before we begin, tell us where in the world you are watching from and what time it is where you are right now. Now, let us begin the story. My father used to say that the smallest seed can expose the biggest lie. On the first warm Saturday of April, I walked into my front yard carrying a metal trowel, a 5-gallon bucket of compost, and 6 young heirloom tomato plants that I had been raising inside my garage since late winter. The morning air smelled like freshly cut grass, damp soil, and blooming jasmine drifting over the fence from my neighbor's yard. Robins hopped across the lawn while sprinklers clicked rhythmically somewhere down the street. It felt like the kind of peaceful Texas morning that reminded me why I had bought this house in Willow Ridge Estates 3 years earlier. Gardening had always been part of my family. My father believed that growing your own food taught patience better than any classroom ever could, and after he passed away, planting tomatoes every spring became my way of remembering him. I measured each planting spot carefully, leaving nearly 3 feet between every plant so they would have room to grow. I mixed compost into the soil, watered each root gently, and pressed fresh cedar mulch around the stems. Looking across the neat row of young plants, I felt a quiet sense of satisfaction that had nothing to do with money or appearances. They were simply tomatoes growing in the front yard of a house that legally belonged to me. About 20 minutes later, the peaceful morning changed. I heard the slow sound of tires rolling over the pavement before a white sport utility vehicle stopped in front of my driveway. The driver's door opened, and Susan Whitmore stepped out wearing pressed khaki pants, a navy polo shirt embroidered with the HOA logo, and dark sunglasses despite the mild spring sunshine. She carried a clipboard tucked beneath one arm and walked toward me with the confident stride of someone who expected immediate obedience. She looked briefly at the tomato plants before shifting her attention directly to me. "Good morning, Michael," she said with a polite smile that never reached her eyes. "I am afraid those will have to come out." I rested both hands on the wooden handle of my shovel and asked calmly, "Why?" She tapped a printed sheet attached to her clipboard. "Vegetable gardens are not appropriate for visible front yards. They do not meet the community aesthetic standards." I glanced around my property. Freshly mowed lawns stretched along both sides of the street. Flower beds filled with roses, lilies, and colorful shrubs decorated nearly every home. My 6 small tomato plants looked no different from any other healthy landscaping except for the fact that they would eventually produce food. "Can you show me where that rule is written?" I asked. Susan smiled again, although this time it looked noticeably tighter. "You will receive official notice," she replied before turning back toward her vehicle. Less than 48 hours later, an envelope bearing the HOA logo appeared inside my mailbox. The violation notice ordered me to remove every tomato plant within 7 days or begin accumulating daily fines. According to the letter, my yard had failed to maintain the visual standards expected throughout Willow Ridge Estates. I read every line twice before placing the notice neatly inside a folder rather than throwing it away. Years earlier, the attorney who handled my home purchase had given me one piece of advice that suddenly echoed through my mind with surprising clarity. Never argue with paperwork until you have read every piece of your own. Standing beside my newly planted tomatoes as the afternoon breeze gently moved their bright green leaves, I realized I was not looking at 6 ordinary plants anymore. I was looking at the beginning of a question that someone had clearly expected nobody to ask. People rarely lose their rights all at once. Most of the time, they surrender them one unchecked sentence at a time. I carried the violation notice into my home office, placed it carefully on my desk, and resisted every temptation to respond immediately. My coffee had already gone cold, but I barely noticed as I unlocked the metal filing cabinet that had followed me through 3 different houses over the past 15 years. Every important document connected to my home had been stored there since the day I signed the closing papers. Purchase agreements, title insurance, survey maps, property tax records, homeowners association documents, and correspondence from the original builder all sat inside neatly labeled folders. I remembered my real estate attorney smiling as he slid the final stack of papers across the conference table on closing day. Before shaking my hand, he gave me one piece of advice that seemed almost unnecessary at the time. He said that most homeowners carefully read the mortgage, but almost nobody ever reads the governing documents after moving in. He told me that many neighborhood disputes begin because people rely on what someone says instead of what the recorded documents actually say. At the time, I had simply nodded, thanked him, and stored everything away without imagining I would ever need it. Now, sitting quietly in my office with the violation notice beside me, those words suddenly carried far more weight. I began with the declaration of covenants, conditions, and restrictions recorded when Willow Ridge Estates was first developed decades earlier. Page after page outlined architectural standards, maintenance obligations, fencing requirements, drainage easements, landscaping responsibilities, and board authority. Nothing about vegetable gardens immediately stood out. Instead of becoming frustrated, I slowed down even more. Years of working as a landscape engineer had taught me that rushing usually causes people to overlook the one detail that changes everything. I continued comparing the declaration with later amendments adopted by the association over the years. Several revisions updated mailbox designs, roofing materials, exterior paint colors, and irrigation requirements. Again, nothing clearly prohibited growing vegetables inside a privately owned yard. That afternoon, I spread my property survey across the dining room table beside the original subdivision plat. Thin black lines outlined every lot while handwritten notes identified easements, utility corridors, drainage areas, and building setbacks. My own lot appeared almost identical to the neighboring properties except for a small notation near the front boundary referencing an attachment filed with the county during the original subdivision approval. The notation itself explained very little, but it immediately caught my attention because none of the HOA documents I had received from Susan mentioned any attachment at all. I highlighted the reference before making a copy for my records. The following morning, I visited the county clerk's office, a quiet brick building where rows of archived property records stretched farther than most people would ever imagine. The clerk at the public records counter patiently helped me locate the original subdivision filings dating back several decades. Thick folders containing plats, engineering drawings, recorded declarations, amendments, and supporting exhibits filled the research table in front of me. As I carefully reviewed each document, I realized something important. The original filing referenced supplemental exhibits that had not appeared anywhere inside the packet provided by the Homeowners Association. I requested certified copies of every attachment connected to my property, paid the copying fee, and carried the envelope back to my truck without opening it in the parking lot. Experience had taught me that significant discoveries deserve careful attention rather than emotional reactions. Driving home beneath the bright Texas afternoon sun, I placed the sealed envelope on the passenger seat beside me and glanced once in the rearview mirror toward Willow Ridge Estates. Somewhere inside those certified county records, I had a growing feeling that the complete story of my property had been written long before Susan Whitmore ever decided that 6 tomato plants did not belong in my front yard. The strongest evidence usually arrives disguised as an ordinary piece of paper. I waited until I returned home before opening the certified envelope from the county clerk's office. Sitting at my dining room table with a legal pad beside me, I carefully spread every document across the polished oak surface. Some pages contained engineering drawings covered with measurements and handwritten approval notes from decades earlier. Others included recorded exhibits attached to the original subdivision filing that had never appeared inside the Homeowners Association packet I received after buying my house. I read each page slowly, highlighting only the sections directly related to my property. Nearly an hour passed before one particular exhibit stopped me completely. Tucked behind the subdivision plat was a recorded appendix describing a small group of lots identified as residential garden lots. According to the original filing, those designated properties retained the permanent right to cultivate edible plants within landscaped front yards as long as the gardens remained properly maintained and did not interfere with drainage easements or public safety. My address appeared clearly listed among those protected lots. I read the paragraph again, then a third time, making certain I had not misunderstood the language. The wording was straightforward, the county recording stamp was clearly visible, and the exhibit had been filed together with the original governing documents long before the first family ever moved into Willow Ridge Estates. Instead of celebrating, I began comparing the appendix against every amendment adopted by the Homeowners Association over the years. None of the later revisions specifically revoked or modified the recorded garden provision. In fact, several amendments referred back to the original declaration while stating that any rights not expressly amended remained in effect. That detail mattered because it meant the protection attached to my property had never disappeared simply because nobody talked about it anymore. The following week, another envelope arrived from the Homeowners Association. The daily fines had officially begun accumulating because my tomato plants remained exactly where I had planted them. Susan Whitmore also informed me that the board expected immediate compliance before the next monthly meeting. I placed the notice beside the county records without responding. Every letter received its own dated folder. Every envelope remained unopened until I could photograph it for my files. Every communication became part of a timeline rather than an argument. A few neighbors noticed the small tomato plants growing taller each day and stopped to ask whether I planned to remove them. I smiled politely and answered only that I was reviewing property records before making any decisions. Some quietly admitted they thought the rule seemed unreasonable. Others assumed the Homeowners Association probably knew its own governing documents better than anyone else. I understood both reactions because authority often creates confidence even when confidence is unsupported by records. Later that evening, I attended the monthly HOA meeting. Susan stood confidently at the front of the clubhouse discussing landscaping standards, architectural approvals, and community appearance before announcing that enforcement actions would continue against any homeowner refusing to correct documented violations. She never mentioned my address directly, but everyone understood the reference when several people glanced toward the back of the room where I quietly sat taking notes. I did not interrupt. I did not argue. I simply wrote down every statement exactly as it was presented. Walking back to my truck beneath the warm Texas evening sky, I realized the situation had quietly changed. Only a week earlier, I had been searching for answers. Now I possessed certified county records suggesting the answer had existed from the very beginning. The real question was no longer whether I had the right to grow tomatoes in my own front yard. The real question was why the Homeowners Association appeared determined to enforce a restriction that the original recorded documents did not seem to support. The moment someone files a lawsuit, opinions stop matching and documents begin speaking for themselves. 3 weeks after the first violation notice appeared in my mailbox, a certified envelope arrived from the district court. The Homeowners Association had officially filed a civil lawsuit seeking an injunction requiring me to remove the tomato plants, comply with the architectural standards they claimed governed my property, and pay the accumulated fines together with legal expenses. I read every page slowly before placing the documents inside a new binder labeled Court Proceedings. There was no anger, no surprise, and no panic. In many ways, I had expected this moment ever since Susan Whitmore confidently walked across my lawn with her clipboard. The difference now was that the disagreement had moved into a place where recorded facts carried more weight than confident assumptions. The following morning, I scheduled a meeting with the same attorney who had handled my home purchase several years earlier. As soon as he saw my name on the appointment calendar, he smiled and asked whether the old filing cabinet had finally proven useful. I placed the lawsuit beside the certified county records, the original declaration, every amendment, my property survey, copies of every violation notice, dated photographs of the tomato plants, and the appendix identifying my lot as one of the designated residential garden lots. He reviewed each document without interruption, occasionally making handwritten notes in the margins before turning back to the recorded appendix. After reading the language several times, he leaned back in his chair and quietly nodded. He explained that recorded property rights attached to the land itself carried significant legal weight and could not simply disappear because later board members overlooked or ignored them. He cautioned me that litigation always required patience because courts examine complete records rather than isolated documents. But he also emphasized the importance of preserving every communication exactly as I had done. Before leaving his office, We organized every exhibit into chronological order so the timeline would remain absolutely clear from the first tomato planted to the filing of the lawsuit. Over the following days, my attorney prepared the formal response while I continued caring for the garden exactly as I had since spring began. Every morning, I watered the plants before sunrise, tied growing vines to wooden stakes, removed small weeds by hand, and watched tiny yellow blossoms slowly develop into clusters of green tomatoes. Neighbors walking past often slowed down to ask how the case was progressing. I answered politely that everything was moving through the legal process and that I preferred letting the court review the documents before discussing opinions. Several people admitted they had started reading their own governing documents for the first time after hearing about the lawsuit. That observation alone reminded me how easily people assume they understand their rights until someone challenges them. At the next HOA meeting, Susan appeared even more confident than before. She informed homeowners that the board remained committed to protecting neighborhood standards through consistent enforcement and stated that legal action sometimes became necessary when voluntary compliance failed. Once again, she never mentioned my name directly, yet the silence that followed made it obvious everyone understood the subject. I remained seated near the back of the room, taking careful notes without asking a single question. Walking outside beneath the fading orange Texas sunset, I looked across the street toward my front yard, where 6 healthy tomato plants swayed gently in the evening breeze. The lawsuit had never really been about vegetables. It had become a test of whether recorded property rights still meant exactly what the county records said they meant, even when an entire homeowners association insisted otherwise. The document everyone overlooks is often the one that changes the entire case. A week after our formal response was filed with the court, the legal process entered discovery, requiring both sides to exchange documents relevant to the dispute. My attorney explained that this stage rarely attracted public attention, yet it often determined how a lawsuit ultimately ended because facts had very little room to hide once both parties were obligated to produce records. While the Homeowners Association requested photographs of my front yard, copies of my correspondence, and maintenance records for the property, we requested something far more specific. We asked for every internal document referencing residential garden lots, every legal opinion concerning landscaping restrictions, every board meeting minute discussing front yard vegetable gardens, every architectural guideline revision, and every communication involving enforcement of those rules during the previous 10 years. The requests were narrow, professional, and directly connected to the issues raised in the lawsuit. Several weeks passed before the association delivered multiple binders of responsive documents. My attorney and I spent 2 full afternoons reviewing every page together inside his conference room. Most of the material contained ordinary administrative records, landscaping applications, meeting agendas, contractor invoices, and homeowner correspondence. Nothing seemed unusual until we reached a collection of archived board meeting minutes from nearly 8 years earlier. During one discussion about updating neighborhood appearance standards, a former board member had specifically asked whether certain lots retained recorded gardening rights under the original subdivision documents. According to the minutes, the association's legal advisor at that time responded that the recorded appendix identifying residential garden lots remained part of the governing property records and could not be eliminated without following a formal legal amendment process involving affected property owners. The discussion ended with a recommendation that future architectural guidelines should acknowledge those recorded exceptions whenever enforcement questions arose. I read the paragraph twice before handing the binder to my attorney. He quietly highlighted the page and placed a colored tab beside it without saying a word. A few pages later, we found another board memorandum prepared several years afterward. The memorandum reminded directors that certain properties possessed unique recorded rights established during the original development of Willow Ridge Estates, and advised board members to verify county records before issuing landscaping violations involving those addresses. My property appeared on the attached reference list. There was no dramatic confession, no hidden scandal, and no sensational language. Instead, there was something far more significant. The association had possessed internal records acknowledging the very exception now being challenged in court. Whether current board members had forgotten those records or simply failed to review them remained unclear, but the documents themselves spoke with remarkable consistency. My attorney explained that the discovery process had accomplished exactly what it was designed to accomplish. It replaced competing opinions with authenticated evidence preserved through ordinary business records. Back at home, my tomato plants had grown nearly 4 feet tall, supported by sturdy cedar stakes and covered with clusters of ripening fruit turning from pale green to deep shades of orange and red beneath the warm Texas summer sun. Every evening, I walked slowly through the garden carrying a watering can while the scent of tomato vines mixed with freshly cut grass drifting across the neighborhood. Looking at those healthy plants, I realized they had become far more than a family tradition honoring my father. They had quietly led us toward records that might never have been examined if 6 simple tomato plants had not inspired someone to send a violation notice. Sometimes truth does not reveal itself through extraordinary discoveries. Sometimes it waits patiently inside forgotten meeting minutes, preserved year after year, until one ordinary disagreement finally gives someone a reason to read them carefully. The truth became impossible to ignore once every document began confirming the same conclusion. Late one Monday afternoon, my attorney called and asked me to come to his office because the Homeowners Association had produced one final collection of records in response to supplemental discovery requests. When I arrived, several new binders sat neatly arranged across the conference table beside the files we had already reviewed over the previous weeks. My attorney explained that the association had located archived correspondence between former board members, outside legal counsel, and the original property management company dating back nearly 15 years. None of the letters contained dramatic admissions or emotional language. They simply documented routine legal guidance provided whenever questions arose about the unique status of certain properties within Willow Ridge Estates. As we carefully examined each letter, a remarkably consistent pattern emerged. Multiple attorneys had independently advised successive HOA boards that the residential garden lot appendix remained legally attached to the original recorded declaration and continued protecting the identified properties unless properly amended through the procedures required by state law and the governing documents themselves. Even more significant, several board orientation packets included written reminders encouraging newly elected directors to review those protected lot designations before approving enforcement actions involving landscaping disputes. My property appeared on every reference list. There was no indication that anyone had ever completed the amendment process necessary to eliminate those recorded rights. Instead, the records showed that previous boards had simply chosen to recognize the exception while focusing enforcement efforts elsewhere. My attorney quietly closed the final binder before looking directly at me. He explained that the issue was no longer whether my property possessed the recorded gardening right. The evidence overwhelmingly supported that conclusion. The remaining question involved why the current board proceeded with litigation despite the association's own historical records consistently acknowledging the exception. During the following week, attorneys for both sides participated in formal depositions. I answered every question honestly, relying only upon dated records, certified copies, photographs, and correspondence rather than personal opinions. My attorney later summarized portions of the deposition transcripts for me. Several current board members acknowledged they had relied primarily upon recent architectural guidelines without personally reviewing the original recorded subdivision exhibits. Others stated they had trusted the enforcement recommendations presented during board meetings because they believed prior legal research had already been completed. Susan Whitmore testified that she understood the association possessed authority to maintain neighborhood standards, but admitted she had never personally examined the archived county appendix identifying residential garden lots before approving the violation notice issued against my property. Her testimony remained respectful and professional throughout, yet it revealed something surprisingly ordinary. The lawsuit had not grown from careful examination of the governing records. It had grown from assumptions carried forward over time without independent verification. Driving home after reviewing the deposition summaries, I passed my front yard where heavy tomato vines bent beneath the weight of bright red fruit ready for harvest. Children riding bicycles slowed down to admire the garden, while several neighbors waved from nearby driveways. What had once been viewed as a violation now looked like nothing more than a healthy, carefully maintained landscape producing fresh food beneath the Texas summer sun. standing quietly beside the tallest tomato plant that evening. I remembered my father's favorite lesson whenever we worked together in the garden. He believed healthy roots mattered far more than impressive leaves because strong roots quietly support everything growing above them. Looking back over the months since I planted those first 6 seedlings, I realized the same principle applied to the case itself. The visible dispute had always been about tomatoes, but the roots of the entire conflict reached much deeper into forgotten records, overlooked responsibilities, and the simple habit of accepting assumptions without taking the time to verify them. Courthouses have a way of making every confident opinion sound much smaller than a verified document. The hearing took place on a clear Tuesday morning beneath a bright Texas sky. My attorney and I arrived early carrying several organized binders containing certified county records, subdivision plats, recorded declarations, amendments, board meeting minutes, deposition transcripts, and the archived correspondence produced during discovery. Across the courtroom, Susan Whitmore sat beside the Homeowners Association's legal counsel reviewing their own files with the same quiet professionalism that had characterized the entire case. There were no dramatic confrontations, no raised voices, and no emotional speeches. The atmosphere remained respectful because everyone understood that the outcome would depend upon the governing documents rather than personal feelings. Once the hearing began, the association argued that maintaining consistent neighborhood appearance standards represented an essential responsibility of the board and that front yard vegetable gardens conflicted with the community's architectural expectations. Their attorney presented copies of current landscaping guidelines and enforcement procedures adopted by recent boards. When our turn arrived, my attorney approached the podium with the original recorded subdivision declaration, the certified appendix identifying residential garden lots, and the county recording certificates establishing that the documents had remained part of the official property record since the neighborhood was first created. One by one, each exhibit was introduced into the record. The subdivision plat identified my address among the protected lots. The recorded appendix expressly preserved the right to cultivate edible plants under clearly defined maintenance standards. Later amendments confirmed that unmodified recorded rights remained effective unless properly amended through the required legal procedures. Finally, the archived board minutes and legal memoranda demonstrated that previous boards had repeatedly acknowledged the continued existence of those protected property rights. The judge spent considerable time reviewing the documents personally before asking several detailed questions concerning the amendment process required under both Texas property law and the governing declaration. Attorneys for both sides agreed that no formal amendment eliminating the residential garden lot provision had ever been recorded. They also agreed that the appendix remained attached to the original declaration filed with the county. Those admissions quietly narrowed the dispute until only one issue remained: whether current landscaping guidelines could override a recorded property right that had never been lawfully amended. After a brief recess, the court returned with its ruling. The judge explained that recorded covenants and property rights attached to the land itself carried controlling legal authority unless modified through the procedures required by the governing documents and applicable law. Because no evidence demonstrated that the residential garden lot appendix had ever been properly amended or removed, my recorded right to cultivate edible plants within the maintained front yard remained fully enforceable. The court dismissed the Homeowners Association's claims, ordered the requested injunction denied, and directed that the accumulated violation fines connected to my tomato garden be withdrawn. Listening to the ruling, I felt remarkably calm. Months of careful research, patient documentation, and disciplined preparation had reached exactly the place my father always believed honest work eventually arrives. Outside the courthouse, several neighbors who had attended the hearing quietly congratulated me, not because tomatoes had won a lawsuit, but because recorded property rights had been respected exactly as they had been written decades earlier. As my attorney gathered the binders into neat stacks before placing them inside his briefcase, he smiled and made one simple observation that stayed with me long after we left the courthouse. The strongest case is rarely the loudest one. It is the one where every independent document quietly agrees with every other document until the truth no longer requires anyone to argue on its behalf. The courtroom ruling ended the lawsuit, but it also started a conversation that spread through Willow Ridge Estates faster than any neighborhood newsletter ever could. Within days, homeowners began requesting copies of the governing documents, county records, and meeting minutes that had been discussed during the hearing. People who had lived in the community for years admitted they had never seen the original recorded declaration, much less the archived exhibits attached to it. Instead of relying on rumors, many residents started reading the documents for themselves. The atmosphere throughout the neighborhood gradually shifted from frustration to curiosity. Questions that had once been dismissed during board meetings were now being asked respectfully and supported by written references. The board announced a special membership meeting to discuss the outcome of the litigation, future governance, and the financial impact of pursuing a lawsuit that the court had determined should never have been filed in the first place. On the evening of the meeting, nearly every chair inside the clubhouse was occupied long before the scheduled starting time. Homeowners quietly exchanged copies of public records while board members organized binders at the front of the room. Susan Whitmore opened the meeting with a calm statement acknowledging the court's decision and confirming that the association would fully comply with every order issued by the judge. She also recognized that the governing records should have been reviewed more carefully before enforcement action was approved. Her comments remained professional, and nobody interrupted while she spoke. Once the floor opened for homeowner discussion, the conversation focused less on my tomato garden and more on how similar mistakes could be prevented in the future. Several residents expressed concern that important historical records had become disconnected from the day-to-day operations of the association. Others asked why newly elected board members had not received complete training regarding the original governing documents recorded with the county. One retired accountant suggested annual legal reviews whenever architectural policies were updated. Another homeowner recommended creating a digital archive so every resident could access recorded property documents without submitting formal requests. Listening from the back of the room, I realized the community was no longer searching for someone to blame. It was searching for a better system. After nearly 2 hours of respectful discussion, one homeowner introduced a motion calling for a vote of confidence regarding the current board. The motion reflected concerns about oversight, document review procedures, and the decision to authorize litigation without fully examining the recorded property records. Ballots were distributed according to the association's governing procedures, and independent volunteers counted every vote while homeowners waited quietly. When the final tally was announced, the membership had voted to remove the existing board and conduct a special election under the procedures outlined in the declaration. Susan accepted the result without argument, thanked the homeowners for the opportunity to serve, and gathered her meeting materials before quietly leaving the clubhouse. Watching that moment unfold, I felt no satisfaction in seeing anyone lose a position. Leadership carries difficult responsibilities, and honest mistakes can happen when systems fail. The important lesson was that accountability had functioned exactly as it was designed to function. Homeowners reviewed the facts, followed the governing procedures, respected the voting process, and peacefully selected new leadership. As I walked outside beneath the warm Texas evening sky, I noticed several neighbors stopping to admire the row of healthy tomato plants glowing softly beneath the porch lights. Those plants had never changed. The documents had never changed. What changed was the willingness of an entire community to read the records for themselves before allowing assumptions to become policy again. The sweetest harvest is never measured by what grows in the garden. It is measured by what grows inside the people who choose truth over convenience. Nearly 6 months after the special election, Willow Ridge Estates felt like a different neighborhood without losing the quiet character that had attracted me there in the first place. The new board introduced a simple principle at its very first meeting. Every significant decision would begin with the recorded governing documents before anyone discussed opinions, traditions, or assumptions. Digital copies of the original declaration, every amendment, subdivision plats, county exhibits, and legal reference materials became available to every homeowner through the association website. Annual board orientation now included a review of the original recorded property rights affecting individual lots, ensuring that future volunteers understood the complete history of the community before making enforcement decisions. Meeting agendas were published well in advance, Homeowners received supporting documents before major votes, and legal questions were answered with written references instead of informal recollections. Those changes did not make the neighborhood perfect, but they made it far more transparent. My front yard changed as well. By late summer, the tomato plants had produced more fruit than I could possibly use. Every Saturday morning, I filled small baskets with bright red heirloom tomatoes and shared them with neighbors walking past the house. Some laughed as they remembered how 6 tiny seedlings had somehow become the center of a lawsuit that reshaped an entire homeowners association. Others admitted they had started reading every document connected to their own property because of everything that had happened. More than once, a new homeowner stopped beside the garden and asked why I had never removed the plants while the lawsuit was still pending. I always gave the same answer. I never planted tomatoes to challenge anyone. I planted them because they belonged in my garden under rights that had already been recorded long before I purchased my home. Once I confirmed those rights through the proper records, there was no reason to surrender them simply because someone misunderstood the documents. One cool autumn afternoon, I opened the old filing cabinet in my home office and looked through the binders that had slowly grown throughout the case. The first folder still contained the original violation notice. Behind it rested photographs of 6 young tomato plants, certified county records, court filings, discovery documents, meeting minutes, deposition transcripts, and finally the court order dismissing the lawsuit. Every page represented another reminder that patience often accomplishes what frustration never can. I closed the cabinet without throwing anything away. Those records no longer represented conflict. They represented the value of preserving facts until the proper time arrived for those facts to be heard. As the sun settled behind the trees that evening, I walked into the garden carrying a woven basket and picked the final ripe tomatoes of the season. The cool breeze carried the familiar scent of fresh earth, cedar mulch, and ripening vines, reminding me of the morning when this journey first began. My father was right all those years ago. A single seed can reveal far more than anyone expects if it is planted in the right place and given enough time to grow. Looking across my quiet front yard, I realized the greatest victory had never been winning a lawsuit or watching an entire board step aside. The greatest victory was proving that ordinary homeowners can protect their rights without anger, without revenge, and without shouting, simply by reading the records, respecting the law, remaining patient, and allowing documented truth to speak for itself when the time finally comes.